Welcome to the webinar on Section 504 of the Rehabilitation Act of 1973, What Educators Need to Know. The mission of the Pennsylvania Training and Technical Assistance Network patent is to support the efforts and initiatives of the Bureau of Special Education and to build the capacity of local educational agencies to serve students who receive special education services. PDE's commitment to the least restrictive environment. Our goal for each child is to ensure individualized education program teams begin with the general education setting with the use of supplementary aids and services before considering a more restrictive environment. The contents of this professional development is not a substitute for legal counsel. We have all been administrators, and we know that situations come up that are complicated and challenging. We know that schools, parents, and courts may have different interpretations of the regulations in different situations. We want to emphasize that the information we provide today is not a substitute for the advice of legal counsel. When those tough legal questions arise, we would encourage you to consult your district solicitor. For questions related to compliance, please contact your Bureau advisor. The agenda for today's webinar is to review the legal history and background, the eligibility criteria and definitions, service agreements, the local educational agency responsibilities and information, 504 versus IDEA, litigation surrounding 504 versus IDEA, and current trends and questions. The objectives for today's webinar are to gain an understanding of the federal and state regulations related to Section 504, to define the term disability related to Section 504, to identify the anti-discrimination protections for all 504 eligible students, to identify the components of service agreements and types of services and accommodations available, to understand the LEA responsibilities under Section 504, and to problem solve potential 504 solutions related to specific case studies.
Let's discuss the legal history and background of Section 504 and the Rehabilitation Act of 1973. The Rehabilitation Act of 1973 was signed into law in September by President Richard Nixon. It replaced the Vocational Rehabilitation Act of 1973 and prohibited discrimination on the basis of disability in programs that receive federal financial assistance. Section 504 is included in the Rehabilitation Act. Every school district must ensure that no student shall, on the basis of race, religion, creed, color, marital status, sex, sexual orientation, national or ethnic origin, or disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity. Section 504 covers the area of public elementary and secondary schools. Free appropriate public education, or FAPE, must be provided to each qualified student with a disability who is in the school district's jurisdiction, regardless of the nature or severity of the disability. In other words, it's illegal for schools to discriminate on the basis of disability by providing an opportunity to participate or benefit that is unequal to that provided to others, that is not as effective as that provided to others, or providing lower quality benefits, services, or programs than those provided to others. It's illegal for a school to use policies and practices that, intentionally or not, result in discrimination. To this end, schools must make accommodations and modifications to address the needs of students with disabilities. The Americans with Disabilities Act was signed into law by President George H.W. Bush in July of 1990 and was modeled after the Civil Rights Act of 1964 and Section 504 of the Rehab Act. It was considered the equal opportunity law for people with disabilities. The ADA was amended in 2008 and was called the ADA Amendments Act, signed into law by President George W. Bush. It broadened the definition of the term disability, expanded the list of major life activities, lowered the standard for substantial limitation, and includes a mitigating measures rule, which states you must not consider the ameliorating effects of measures such as medication or mobility devices, when determining eligibility as a student with a disability. To be equally effective, aids, benefits, and services do not have to produce identical results, but must afford equal opportunity to obtain the same results in the most integrated setting appropriate. A qualified student with a disability may not be denied the opportunity to participate in a program or activity that is not separate or different. Providing unnecessarily separate or different services is a discriminatory practice under Section 504. For aids, benefits, or services provided to be equally effective, they are not required to produce the identical result or level of achievement for handicapped and non-handicapped persons, but must give students with disabilities an equal opportunity to obtain the same results, gain the same benefit, or reach the same level of achievement, and it's to be done in the most integrated setting appropriate to the person's needs. Chapter 15 is Pennsylvania's interpretation of the federal law of Section 504. Similar to comparing IDEA in Chapter 14, schools must comply with both 504 and Chapter 15. State regulations must comply with federal regulations, but may exceed federal requirements. Educators need to be aware of the differences. Here's an example of a 504 and Chapter 15 difference. Section 504 regulations do not require a written agreement for a student who requires a plan. Chapter 15 does require a plan to be written. Refer to your handout titled Protected Handicapped Students of Chapter 15. Section 504 is an anti-discrimination law that focuses on equal opportunity and equal treatment of students with disabilities. Unfortunately, school districts have broken this rule and excluded students from a participation in an activity or allowed a student to be treated differently due to a disability. Here are some examples of how school districts intentionally or unintentionally allowed a student to be discriminated against. Expels a student from school for misbehavior that is related to his or her disability. Declines to provide transportation that is as short in duration as provided to a student without disabilities. Declines to allow a student with a disability the opportunity to audition for athletic teams, cheerleading, or other extracurricular activities. Denies course credit to a student whose absenteeism is the result of a disability. Declines to dispense medication to a student who needs it to benefit from education. Fails to provide information to a student parent about the special provisions of college board exams available to students with disabilities. Does not provide an interpreter for a parent who needs one to attend a mandatory meeting. Forces student to leave school 45 minutes early daily because that is when the bus for students with disabilities has to leave to pick up others. Think about this question. Do private schools have to comply with Section 504 regulations? The answer could be yes or no. It depends. Section 504 covers programs that receive federal funds. Public schools, including charter schools, receive federal funds, so they must comply. Private schools who receive federal funds have to comply as well. Section 504 focuses on equal opportunities and equal treatment. It is an anti-discrimination law. Courts have made a broad definition of receiving federal funds to include direct or indirect funding, school lunch programs, technology grants, anti-drug programs, and government loans. Section 504 does not apply to schools that are 100% tuition-driven or have no government funding sources or programs. 29 U.S. Code, Section 794, titled Non-Discrimination Under Federal Grants and Programs, in simple terms states if there is any receipt of federal financial assistance by any school, they must comply with Section 504. So what is federal financial assistance? Federal financial assistance means any grant, loan, contract other than a procurement contract or a contract of insurance or guarantee, or any other arrangement by which the department provides or otherwise makes available assistance in the forms of funds, services, real and personal property, transfers or leases of such property, and proceeds from a subsequent transfer or lease of such property. For schools, examples of federal financial assistance include the following: free and reduced lunch, federal milk, federal energy grant, Title I remedial education, Title II Eisenhower professional development, Title III technology, Title IV drug-free schools, Title VI innovative programs. An example of a private school that received federal financial assistance in this slide refers to Hunt versus the St. Peter's School. They are a Catholic school serving K-8, and they had to comply with Section 504 because they received federal funds through Title I and the National Free Lunch and Breakfast Program. In addition to receiving federal financial assistance, private schools also have certain obligations they need to follow. The first, 10434, titled Educational Setting, involves the least restrictive environment mandate. The second example, under 10437, titled Non-Academic Services, provides for an equal opportunity to participate in non-academic and extracurricular services. The third example, under 10439, titled Private Education, states a recipient that provides private elementary or secondary education may not, on the basis of handicap, exclude a qualified handicapped person if the person can, with minor adjustments, be provided an appropriate education. There's no definition in regulations of what are considered minor adjustments, but they can be related aids and services, tutorial services, extended time to take exams, special seating arrangements, or non-content modifications. Minor adjustments are not establishing a new program, hiring additional staff to work only with the student with a disability, persistent disruption of classes or other students' learning, taking time away from teachers' regular responsibilities, or putting health and safety of other students at risk.
Now we are going to talk about eligibility criteria and definitions. This screen gives you the three major qualifications for 504. The student must have a physical or mental impairment that substantially limits one or more major life activities. For example, a student who has cancer and is going through chemotherapy and may need continuous breaks in the nurse's office throughout the school day in order to stay focused in class as long as possible. Or have a record of such impairment. A student who no longer meets eligibility criteria for a special program for students with disabilities, a former IDEA eligible student, is an example of someone who has a record of having a disability. Another criteria is being regarded as having such an impairment. Individuals who are regarded as having a physical or mental impairment when in fact such impairment may or may not actually exist are protected from discrimination under Section 504. So any student who has one of the three qualifications is protected from discrimination under Section 504. However, to qualify for a Section 504 service agreement, a student must currently have a physical or mental impairment that substantially limits one or more major life activities. So in general, Section 504 is a two-pronged criteria. All students who have a disability, have a record of a disability, or are regarded as having a disability are protected from discrimination under Section 504. And some of those students who qualify under the first definition may require a Section 504 service agreement in order to have equal access to education in the least restrictive environment. Here we are going to talk about the physical or mental impairment under the definition of a disability under Section 504. Remember, it is only the definition that ensures students to the right to a 504 service agreement, which entitles the student to FAPE. The requirements of a free appropriate public education under Section 504 are more limited and require additional analysis. Being identified as a student with a disability is necessary, but is not sufficient to establish a need for FAPE under Section 504. We are going to go over this in depth Let's start with what a physical or mental impairment is. For the purpose of IDEA, the LEA needs to look at the child in relation to one of the 13 disability categories. Section 504 covers a much broader array of conditions and/or disorders. This is simply an illustrative list of what is to be considered. It is not an exhaustive list. Keep in mind that an impairment in and of itself is not a disability. The impairment must substantially limit one or more major life activities in order to be considered a disability under Section 504. Examples in addition to this slide include contagious and non-contagious diseases and conditions, hearing impairments, cerebral palsy, epilepsy, muscular dystrophy, multiple sclerosis, cancer, heart disease, diabetes, HIV symptomatic or asymptomatic, and tuberculosis. The second part of this physical or mental impairment are things such as intellectual disability, organic brain syndrome, emotional or mental illness, or specific learning disabilities. So what are some possible impairments? This list is not an exhaustive list. Again, these are just some examples. Now we are going to look at some non-examples of impairments. These situations in and of themselves are not considered impairments. Rather, decisions need to be based on a case-by-case basis. For example, a student who has gender identity disorder would not automatically be obligated to receive a Section 504 plan. However, should that student have depression related to his or her gender disorder, then that should be looked at to see if it substantially limits a major life function. And if it is, then that student may be entitled to a Section 504 plan. Again, decisions need to be made on a case-by-case basis. We've just gone over what a physical or mental impairment is. But remember, the student has to meet all three prongs in order to be considered for a 504 service agreement and FAPE. This is what is important to remember. All three prongs need to be present in order to qualify for a 504 service agreement. Let's go over what substantially limits means. Here are the 9 rules on substantially limits. Substantially limits is not intended to be a demanding standard. It should not demand extensive analysis. It must only limit one major life activity. An impairment that is episodic or in remission qualifies as a disability if it would substantially limit a major life activity when active. An impairment does not need to prevent or significantly or severely restrict an individual from performing a major life activity to be substantially limiting. It's not defined in Title II regulations what substantially limits means. However, it is included in these 9 rules of construction. The Department of Justice explained that those rules provide ample guidance on determining whether an impairment substantially limits a major life activity. So let's look at rules 6 through 9. Individualized assessment needed. They do not need to produce scientific, medical, or statistical evidence to show how performance of a major life activity compares to the performance of most people in the general population. The effects of an impairment lasting or expected to last less than 6 months can be substantially limiting for establishing an actual disability or a record of a disability. And now we're going to look at mitigating measures. Now let's look at mitigating measures. The determination of substantial must be made without regard to the ameliorating effects of any mitigating measures the student is using. This is a change from prior law. When determining if a mental or physical impairment substantially limits a major life activity, you may not consider mitigating measures, with the exception of ordinary eyeglasses or contact lenses. Mitigating measures are devices or practices that a person uses to correct or reduce the effects of the impairment, such as equipment and medications. However, there is a distinction between ordinary eyeglasses, contact lenses, and low vision devices. Regular glasses contacts are meant to correct visual acuity or eliminate refractive error, while low vision devices are meant to magnify, enhance, or otherwise augment a visual image. This means that you must consider whether or not there is a substantial limitation without the consideration of any corrective devices or medication. Now let's look at some examples of mitigating measures. Mitigating measures are often referred to as things that the students come to school with. In other words, these are things that are provided to the child from the parent, including things provided via insurance and medical doctors. For example, if a child needs an inhaler, that is not something that the school provides. The ADAA clarifies that the determination of whether an impairment substantially limits a major life activity must be made without regard to the effect of mitigating measures such as medication, equipment, low vision devices, prosthetics, hearing aids, and cochlear implants, mobility devices, oxygen therapy equipment, and supplies. Assistive technology, reasonable accommodations, or auxiliary aids or services, including qualified interpreters, qualified readers, taped texts, and the acquisition, modification of equipment or devices, or learned behavioral or adaptive neurological modification. Districts must now make their Section 504 determinations based upon the child's disability as it presents itself without mitigating measures. How is substantial limitation determined? The determinant, again, is made on a case-by-case basis with respect to each individual student. One example related to substantially limits that was provided by an attorney in an article about 504 was that a student who can walk for 10 miles continuously is not substantially limited in walking because on the 11th mile, he or she starts to feel discomfort. The law requires that a group of knowledgeable persons draw upon information from a variety of sources in making this determination. This means a group that has members that are knowledgeable about the child, the assessments, and the placement and services options must make the determination. Here are some non-examples of substantially limits. These are examples of when an impairment would not substantially limit a student from a major life activity. A mild allergy to eggs that causes a mild rash, or mild depression that does not affect the student's attendance, behavior, or grades. Now let's look at the third area under the definition of a disability under Section 504, major life activity. Here you consider how the person is affected in relationship to most or average people. This relates to substantial as well as major life activities. This is a change from the prior law. Previously, a disability had to affect more than one major life activity. Current law states that the disability only needs to affect one major life activity. Here are some examples of major life activities. Again, not an exhaustive list, but many things and examples to consider that would be considered a major life activity. Here are some special cases and impairments that could be a disability if they limit a major life activity. Temporary impairments. A temporary impairment does not constitute a disability for purposes of Section 504 unless its severity is such that it results in a substantial limitation of one or more major life activities for an extended period of time. The issue of whether a temporary impairment is substantial enough to be a disability must be resolved on a case-by-case basis, taking into consideration both the duration or expected duration of the impairment and the extent to which it actually limits a major life activity of the affected individual. Episodic impairments, or an impairment that is episodic or in remission, is a disability if it would substantially limit a major life activity when active. Some students have physical or mental impairments that ebb and flow in activity and severity. Conditions such as seasonal allergies, asthma, migraines, cystic fibrosis are good examples of impairments that may substantially be limiting at times and have little impact at other times. Impairments in remission, or an impairment that is episodic or in remission, is a disability if it would substantially limit a major life activity when active. For example, a student who had cancer in elementary school could be disabled under prong 1 of Section 504 even though the student's cancer has been in remission for 5 years. If the cancer was substantially limiting when it was active in elementary school, the student could still have an impairment that's in remission. An individual is not regarded as an individual with a disability if the impairment is transitory and/or minor or temporary. A temporary impairment is one with an actual or expected duration of 6 months or less. In addition, the school must protect the child from discrimination whether the condition is active or in remission. Here are some examples of students who were eligible for a 504 service agreement and how their needs were met. Student breaks their arm in 5 places and cannot write. The LEA provided someone to take notes or write the homework. Going down the list, a student uses a wheelchair. The LEA permitted the student to leave class early to avoid hall traffic. Just some examples of disabilities under Section 504 and how their needs were met. Please take a moment to review the statement on the screen. Is this a myth or reality? It's actually a myth. A physical or mental impairment that substantially limits a student's ability to learn in comparison to the average population is a disability under Section 504. The argument that a student who is passing but could do better is not sufficient for Section 504 eligibility with respect to the major life activity or learning. Again, this example comes out of the Council of Administrators of Special Education, the 21 Myths and Realities for School Personnel.
Our next section will focus on 504 service agreements. Section 504 is important for schools because it protects students who are not eligible under IDEA to receive services. FAPE is defined as the provision of regular or special education and related services that are designed to meet the individual educational needs of a disabled student as adequately as the needs of a non-disabled student are met. Everything on this slide relates to the protections under Section 504. However, everything on this slide is not specifically written into a 504 service agreement. Specifically, although students are protected from discrimination in extracurricular and non-academic activities under Section 504, the specific accommodations needed would not be specifically written into a 504 service agreement. But let's look at this a little further and talk a little more specifically about what needs to be included in a Section 504 service agreement. In the state of Pennsylvania, written service agreements are required for students who receive services under Section 504, Chapter 15. You may hear 504 service agreements referred to as plans or accommodation plans, etc. But remember, in the state of Pennsylvania, they are referred to as service agreements. As with IEPs, 504 service agreements are legal documents and must receive all the services documented. All personnel involved with the student should receive a copy of the service agreement. And if the service agreement is not followed, a complaint can be filed with the PA Bureau of Special Education or the Federal Office of Civil Rights. These are some examples of aids, services, and accommodations, but this is not an exhaustive list. You may find it helpful to access the U.S. Department of Education's recommendations from the guidelines for educators and administrators for implementing Section 504 of the Rehabilitation Act of 1973, Subpart D. Specifically, pages 35 to 39 are general strategies. Appendix E, pages 95 to 111, are examples of disabilities and accommodations. This will help support you in development of service agreements. Although the required components of a Section 504 service agreement are not prescribed by law, best practices suggest a plan should address the educational impact of the identified disabilities and the services and accommodations necessary to facilitate equal access to education in the least restrictive environment. You may find it helpful to access Pennsylvania's recommended sample 504 service agreement implementation of Chapter 15 packet, which includes PA Code implementation of Chapter 15, sample district-initiated evaluation, sample notice to parents, sample procedural safeguards, sample service agreement. These are the components that must be included in a service agreement. While an individual 504 service agreement may look different for different students, all of them need to include these components. The Section 504 service agreement should indicate what services will be provided, how, when, and where they will be provided, and who will be responsible for monitoring implementation of the Section 504 plan. These are additional recommendations for 504 service agreements. To assure information is available from the family, parents should be invited and encouraged to assist in developing the Section 504 service agreement. Services and accommodations should be based on information and data used in the evaluation and disability determination process. Services and accommodations should address the student's identified disability and need to receive services to ensure that the student's educational needs are met as adequately as those of his or her non-disabled peers. The plan may include self-management of health conditions in the school setting or school activities if needed. Additional recommendations for 504 plans. The plan may include services and accommodations for the school building, classroom, or transportation, administrative adjustments, academic and instructional accommodations, and/or behavioral intervention and testing accommodations. The plan should indicate whether it is an initial plan, a revised plan, or a continuation of an existing plan. A monitoring system should be developed and responsibilities assigned for implementation. Copies of the plan should be distributed to parents, teachers, and any responsible individuals. A copy of the plan should be placed in the student's records. Please think about the statement on the slide. Is it a myth or a reality? It is a myth. Under Section 504, FAPE is defined as the provision of regular or special education and related services that are designed to meet the individual educational needs of a disabled student as adequately as the needs of a non-disabled student are met. A Section 504 plan therefore addresses instructional and education modifications and accommodations, not extracurricular and non-academic activities, unless those activities are necessary for a student to benefit from his or her educational program. Though the issue may not be addressed in Section 504 service agreements, a school system may still not discriminate against an otherwise qualified student with respect to extracurricular and non-academic activities and must make reasonable accommodations to such students to ensure their participation. Now we'll focus on LEA responsibilities and information. LEA 504 responsibilities include conducting appropriate child find and initial evaluations, establishing standards and procedures for the identification and evaluation process, conducting periodic reevaluations of students with disabilities, providing FAPE through the provision of a Section 504 plan to meet the individual educational needs of eligible students as adequately as the needs of non-disabled students are met. FAPE consists of the provision of regular or special education and related services designed to meet the student's individual educational needs as adequately as the needs of non-disabled students are met. Note, this is not the same definition of FAPE that is written into IDEA. providing education to students with disabilities in the least restrictive environment, providing students with disabilities equal access to non-academic and/or extracurricular services, establishing and implementing a system of procedural safeguards regarding the identification, evaluation, placement, or provision of FAPE to a student, ensuring behavior in question is not a manifestation of a student's disability during disciplinary proceedings, providing transportation under specific individual circumstances and conditions, providing equal access to parents who have a disability. 504 is a general education responsibility and regulation, but schools can assign this to special education personnel. However, child fine must still occur. There is a difference between child fine for IDEA and 504. Under IDEA, the LEA could be either the IU or the district school, depending on the circumstances. For 504, the LEA responsible for the child or for child fine is always the district or school. Although there is no statute of limitations of liability, if a child with a 504 service agreement misbehaves and the behavior was not a manifestation of the disability, the child can be expelled from school permanently. This is not the case with IDEA. Chapter 12 allows 30 days for the parent to find a placement for the child. The child is to receive services until age 17. In addition, there is no interim alternative educational placement provision in 504. There is also a difference between a parent revoking IDEA and 504. A parent can revoke IDEA and the school can't legally do anything about it. If the parent revokes 504, the LEA may choose to pursue due process. If the child's 504 protections are removed, a reevaluation must be completed because that would be a major change in placement. Therefore, a school does not automatically have to provide 504 to a student whose parents revoked special education. It should be evaluated on a case-by-case basis. A student who is not entitled to a Section 504 Chapter 15 service agreement for services, accommodations, or modifications if parents revoke consent for special education programs and services. Following the change in special education regulations granting parents the right to revoke consent, staff in the Office for Civil Rights, the U.S. Department of Education, would not respond to an inquiry regarding whether a Section 504 Chapter 15 service agreement must be provided when parents revoke consent for special education programs and services under the IDEA. There is, however, a 1996 OCR opinion letter to McKeithen. OCR staff stated, once a school district has found a student disabled within the meaning of the IDEA and has developed an IEP in accordance with the law's requirements, it is impermissible for the student's parents to refuse to accept IDEA services as specified therein and require the district to develop an IEP under Section 504. Thus, a rejection of services under the IDEA would amount to a rejection of services offered under Section 504. And in these situations, the district complied with Section 504 when it complied with the IDEA requirements. Teachers, therefore, are not required to implement those accommodations listed in the student's IEP. Under Section 504, districts continue to have an affirmative duty to identify and locate every qualified disabled child residing in the school district who is not receiving public education, is homeless, in a non-public school, or in a public school. Based on this affirmative duty to identify and locate qualified handicapped children, the school district charter school may need on a case-by-case basis to consider eligibility under 504 for those students whose parents have revoked consent for special education services. Although there are no regulatory timelines for 504, a school district may choose to follow the IDEA timelines, which the courts have defined as reasonable. LEAs must establish standards which are a general statement about what you are going to do. Procedures, an explanation of how you're going to do it. No one will go around and check a district's standards and procedures unless a complaint has been filed with OCR. Standards and procedures are considered to be sufficient if they are reasonably calculated. The parent is not a required member of the team making the determination. However, the group must consider information from the parent. A medical diagnosis may not suffice as an evaluation for the purpose of providing FAPE. A physician's medical diagnosis may be considered among other sources in evaluating a student. A medical diagnosis of an illness does not automatically mean a student is eligible to receive Section 504 services. The illness must cause a substantial limitation on a major life activity. There is no provision of an independent evaluation in Section 504. However, the results of an independent evaluation may be one of the many sources to consider. On the other hand, if the school requires a medical diagnosis as part of the data, then the school must pay for it unless the parents have already had the related medical tests. The school may ask the parent to provide additional medical records, which the parents may have, and to grant the district permission to evaluate the student. There is no regulation that any particular source of data carry any more weight than anything else. The weight of the information is determined by the group depending on the child's individual circumstances. Variety of sources is not defined. However, you would want to consider things like information from the parents and teachers, test data, medical data, behavioral data, etc. The school's procedures should spell out how all of this is to occur. Just as with IDEA, if the parent disagrees with the determination, he or she may request a due process hearing. These are some examples of evaluative sources, but this is not an exhaustive list. Important note regarding reevaluation. If a parent refuses to produce the child for a reevaluation, the school must initiate due process. This is different from IDEA. Consent is not required for reevaluation. It is only required for initial evaluation and for exiting. There are no required timelines, but these are options that a school may decide to follow and write into their procedures for reevaluation. What do you do or could you do in order to ensure that 504 service agreements are being implemented in the classroom? Here are some ideas. Periodic classroom walkthroughs, periodic checking of behavior, periodic checking of grades, check and connect with students, check and connect with teachers. These are common errors that people make regarding 504 service agreement. Let's review. Using a predetermined checklist and checking accommodations or services that are not necessary to ensure Section 504 FAPE. Failing to match services and accommodations with student needs. Failing to provide copies and an explanation of the Section 504 plan to everyone responsible for implementation. Writing vague plans. Providing minimal or no monitoring of the implementation of the plan. Failing to get school administration involved with monitoring of Section 504 plan implementation, and developing a Section 504 plan for a student with an IEP. Please think about the statements on the slide. Are they myths or realities? These are realities. Although Section 504 is an anti-discrimination law that does not require affirmative action to be taken in the development of educational programming, as does the IDEA, and Section 504 is designed to prevent discrimination solely on the basis of disability in the provision of all services, activities, and programs operated by a school district or other federal fund recipient. However, Chapter 15 states that the school district cannot modify or terminate the student's current service agreement without the parent's written consent. Let's dig deeper into Section 504 versus IDEA. This chart is one way to look at who gets IDEA special education services. Section 504 services are no special services. If a student has no disability and no need for special education, they fall into box number 1, regular education. A student who has a disability but doesn't need that specially designed instruction that we talked about earlier may fall into box number 2 and receive a 504 plan. Students who have no disability but need some special instruction anyway fall into box number 3 and could be called struggling learners, or perhaps they haven't mastered the English language yet. And those students who have a disability and need special education are our IDEA children who receive IEPs. In boxes 2 and 4, and in order for a child to qualify for services, they must have a disability. The disability categories for Section 504 and IDEA are different. For Section 504, a student must have a disability that limits a major life activity. IDEA has 13 disability categories into which a student must fall to qualify. Here's an example of how a student would qualify for Chapter 15 services and not Chapter 14 special education. The student has a disability that limits the major life activity of learning, not necessarily one of the 13 disability categories under IDEA. The student only needs accommodations to access regular education, not specially designed instruction that is delivered by a special education teacher. The difference is that 504 accommodations are delivered in the regular classroom by the regular classroom teacher. A student would not have both a 504 plan and an IEP. Under 504, one way to meet the 504 requirements for FAPE is to implement an IEP. This is a flowchart that we found that may help guide employees in the Section 504 process. Please refer to your supplemental handouts. Section 504 and IDEA are federal laws. Chapter 14 and 15 are state laws. We must follow both, but state law supersedes federal law. The main differences with 504 and Chapter 15 follow here. Chapter 15 requires parent permission and involvement. 504 does not. Chapter 15 requires a written service agreement. 504 does not. Please take a minute to think about the statement on the slide. Is it a myth or a reality? It is a myth. Section 504 is an anti-discrimination law that does not require affirmative action to be taken in the development of educational programming, as does the IDEA. Rather, Section 504 is designed to prevent discrimination solely on the basis of disability in the provision of all services, activities, and programs operated by a school district or other federal fund recipient. Let's review some litigation in Section 504. Please pause the presentation to review scenario number 1 as provided with your supplemental materials. Chapter 15 requires that a school district shall provide each protected handicapped student enrolled in the district without cost to the student or family those related aids, services, or accommodations which are needed to afford the student equal opportunity to participate in and obtain the benefits of the school program and extracurricular activities without discrimination and to the maximum extent appropriate to the student's abilities. Therefore, to conclude, the student qualifies for protection under Section 504 and Chapter 15 due to the impact of the student's disability on learning. The district has discriminated against the student by requiring the parents to pay for the accommodations recommended by and set forth in the student's Chapter 15 service agreement. Accordingly, the district will be ordered to provide the required accommodation. Please take a moment to pause the presentation to review scenario number 2 as provided with your supplemental materials. Use the essential questions on the slide to guide your thinking as you review the scenario. The United States Supreme Court has held that the burden of proof in an administrative hearing challenging a special education IEP is upon the party seeking relief, whether that is the disabled child or the school district. Therefore, to conclude, the school district's proposed Section 504 plan is appropriate and she is not eligible for an IEP. The school district's December 2005 evaluation report is appropriate. No personal care assistant is needed. Students' parents are not entitled to reimbursement for the cost of an independent education evaluation. Please refer to these resources for additional information regarding 504. On this slide, you will find our contact information should you need to reach out to us or have a question. Thank you.